as soon as they're done, and I'll take those, the first two out. I'll cut that other half on the back, raise the out, and 14, or 7. And then it's just a turn here.
It's gonna be virtual. The last. Yeah, they'll be at the end and the initial virtual, so they're not kind of.
But that turning back. That turning on here.
Yes.
Okay. All right.
Be seated. All right, this is the 8 a.m. initial appearance calendar for July 26, 2025. I'm going to call you in individually. You're going to go behind the podium. I'm going to tell you what you've been booked on and whether an attorney has been appointed to represent you. I'm also going to give you the date of your next court appearance. I will let you know whether you're eligible for a bond or not. Now, if it's a secured bond, that means you can go through a bonding company. Phone numbers for the various bonding companies are located in the jail cell. You can call any one of them. They will accept collect calls. If it's a cash bond, then you have to pay the entire amount of the bond. I'm also going to tell you if I've set any release conditions, like no going back to the alleged scene of the crime or no contact with the alleged victim. You need to follow each and every condition if you want to remain released. Let me remind you, if you've been ordered by a court not to have contact with the victim and then you do so, you may be charged with an additional felony. Now, when you come into the courtroom, please be aware this is all being video recorded. So do not talk about the facts of your case, as you have the right to remain silent. As you leave the courtroom, court staff's going to give you your paperwork. That's going to show you your current charges, whether an attorney has been appointed to represent you, where, when, what time your next court hearing is going to be, whether you're eligible for a bond or not, and then it'll have a list of all your release conditions. The purpose of this hearing is to determine whether you're eligible for a bond or not. That decision is based on your past criminal history, any failures to appear, Arizona law, and your current charges. It's not based on personal information, so don't go into that. Finally, for the record, the orders for 10-print fingerprinting and the taking of DNA samples that were made on the first calendar of July 1st, 2025, shall apply to all matters on this calendar. Okay, can I have Renee Finstead come on in? And then Cudjoe Young to the chair outside the courtroom. Ma'am, state your name and date of birth.
Renee Lucille Finstead, 7464.
Okay, you have two matters. The first one is a failure to appear for court for one count of possession of narcotic drug, class 4 felony, one count of possession of drug paraphernalia, class 6 felony. This allegedly occurred June 4th of last year. You already have a court-appointed lawyer. Your next hearing is going to be a status conference, July 31st at 8:30. When you didn't go to court, the judge set your bond at $250. Now you've got a Superior Court new case. This alleges one count of possession of dangerous drugs, class 4 felony. I've appointed a lawyer to represent you. Your next hearing is going to be a status conference, July 31st at 8:30. Now, I'm also setting an evidentiary hearing for the very next day, August 1st at 1:30. So Arizona has a criminal rule of procedure. It's 4.2A7A. And what that means is if you're out on release on a felony, like the first one we talked about, and you allegedly commit a new felony, You can't bond out on the new felony.
When does the new felony come in?
The one I just told you about, dangerous drugs possession.
And
So you can't bond out on that. But at that evidentiary hearing that I'm already setting on August 1st, you and your attorney, you get to challenge that and ask the judge to release you or set a bond okay? And that's going to be on August the 1st, okay? All right, get your paperwork from the court staff over there. Cujo Young, come on in. Lorenzo Castillo to the chair outside the courtroom. Sir, state your name and date of birth.
Joe Young, 3596.
All right, you have a grand jury warrant, which means the grand jurors met, they heard testimony, they found probable cause on one count of murder in the first degree, one count of conspiracy to commit murder in the first degree. Those are both class 1 felonies. One count of conspiracy to commit kidnapping, one count of kidnapping, one count of arson of an occupied structure. All of those are class 2 felonies. One count of armed robbery with a deadly weapon, also a class 2 felony. And then one count of theft of means of transportation, class 3 felony. These are various dates, April and March of 2023. I've appointed a lawyer to represent you. Your next hearing will be an arraignment, August 1st at 8:30. The grand jury judge set your bond at $2 million cash. All right, get your paperwork from the court staff. Lorenzo Castillo, come on in. And Junior Montoya to the chair outside the courtroom. Sir, state your name and date of birth.
Lorenzo Castillo, March 5th, 1990.
All right, you have 2 matters. The first one is a Superior Court new case alleging one count of possession of a weapon by a prohibited person. It's a class 4 felony. One count of possession of drug paraphernalia, class 6 felony. I've appointed a lawyer to represent you. Your next hearing will be a status conference, July 31st at 8:30. I set a $10,000 bond. Let me tell you, it looks like you might have a hold from the U.S. Marshals for a probation violation. Now, your second matter that you have is a justice court warrant for one count of knowingly displaying fictitious plates, one kind of open container of liquor in a vehicle. Those are both misdemeanors. I have appointed a lawyer to represent you for the limited representation regarding the bond. Your next hearing on this will be an arraignment, July 30th at 8:30. And the judge set your bond at $500 on that.
Okay.
All right, get your paperwork from the court staff. Junior Montoya, come on in. Jacob Stamper to the chair outside the courtroom. Sir, state your name and date of birth.
Junior Montoya, 03-1706.
All right, you have a Superior Court new case alleging one count of robbery. That's a class 5 felony. I've appointed a lawyer to represent you. Your next hearing will be a status conference, July 31st at 8:30. I set a $10,000 bond. You cannot return to the alleged scene of the crime and no contact with the alleged victim. Get your paperwork from the court staff. Jacob Stamper, come on in. William Ochoa to the chair outside the courtroom. Sir, state your name and date of birth.
Jacob Stamper, September 28th, 1994.
All right, you have 2 matters. First one is from Gila County Superior Court, alleging one count of transportation or sale of narcotic drug, one count of possession for sale of narcotic drug, both class 2 felonies. One count of possession of narcotic drug, one count of possession of dangerous drug, one count of possession or use of a weapon in a drug offense. All those are class 4 felonies. And 1 count of possession of drug paraphernalia, that's a class 6 felony. All of these allegedly occurred February 28th of 2020. You'll have a lawyer appointed for you at your next hearing if you're indigent. I can't appoint you an attorney because this is in Gila County.
What does indigent mean?
Pardon?
What is indigent?
Indigent means that you're not financially able to hire your own attorney. So most courts have a form that you fill out about how much you make, if you have a job and all that, and then they compare that to all your bills. Okay. Your next hearing on this is going to be an arraignment, July 30th at 8:30. And the judge in Gila County set your bond at $8,000. Now, the next matter that you have is a Superior Court arrest warrant, and this is in Maricopa County, alleging 1 count of possession of narcotic drug, class 4 felony. I've appointed a lawyer to represent you. Your next hearing will be a status conference, July 31st at 8:30, and I set a $750 bond here. All right, get your paperwork from the court staff. William Ochoa, come on in. Randy Gregg to the chair outside the courtroom. Sir, state your name and date of birth.
William Ochoa, 10/31/78.
All right, you have a Superior Court new case alleging 1 count of possession of dangerous drugs, class 4 felony. 1 count of possession of drug paraphernalia, class 6 felony. 1 count of criminal damage, class 1 misdemeanor, and 1 count of having an open container of liquor in a vehicle, class 2 misdemeanor. I've appointed a lawyer to represent you. Your next hearing is going to be a status conference, July 31st at 8:30. I set a $3,600 bond. If you post that bond, you've got a long list of conditions you're going to have to follow, okay? Get your paperwork from the court staff. Randy Gregg, come on in. Irma Viller to the chair outside the courtroom. Sir, state your name and date of birth.
Randy Lane Gregg, 11/18/1960.
All right, you've got a Superior Court new case alleging 1 count of possession of dangerous drugs, class 4 felony, 1 count of possession of drug paraphernalia, class 6 felony. I've appointed a lawyer to represent you. Your next hearing will be a status conference, July 31st at 8:30. I set a $2,500 bond. If you post that bond, you've got a list of conditions you're going to have to follow. Get your paperwork from the court staff.
I can't hear you. Number 6 was brought in earlier. I didn't know if you were.
Yeah, is the attorney on? Pardon?
Both attorneys are on.
Oh, okay. Counsel, I was told initially that we were going to do yours last, but I'm going to call you right after this one. Irma? And then Sincere Hayes to the chair outside the courtroom. All right, state your name and date of birth.
Irma Leticia Aguilar, 8/25/87.
Okay, you have a failure to appear warrant for 1 count of unlawful flight from law enforcement, class 5 felony, 1 count of reckless driving, class 2 misdemeanor. Now, you already have a court-appointed lawyer. Your next hearing is going to be a status conference, July 31st at 8:30. Now, when you didn't go to court, the judge set your bond at $2,000 cash. Okay? Get your paperwork from the court staff.
Thank you.
Mr. Hayes, come on in. And then do we have both counsel?
Yes, Your Honor.
Do we have Mr. Romero?
Judge, I'm sorry. This is Gerald Bradley from Public Defender. Just wanted to make sure you could hear me.
Oh, now I can.
Okay. Yeah, I just turned my mic on. I was a little confused on the teams. I just wanted to make sure I didn't interrupt your prior proceedings.
Oh, yeah, no problem. Okay, can you both announce for the record?
Thank you, Your Honor. Brooke Gahn on behalf of the state.
Gerald Bradley for Mr. Hayes, appearing virtually.
Okay. Sir, state your name and date of birth.
Sencere Patrick Hayes, 10/31/2000.
Okay, can you speak up louder so you've got your attorney and they can hear you
Sencere
too?
Patrick Hayes, 10/31/2002.
Okay, sir, you have a Superior Court grand jury warrant, which means the grand jurors met, they heard testimony, they found probable cause on the following. 1 count of conspiracy to commit murder in the first degree. 1 count of murder in the first degree. Those are both Class 1 felonies. 1 count of conspiracy to commit kidnapping. 1 count of kidnapping. 1 count of arson of an occupied structure, and 1 count of armed robbery with a deadly weapon. Those are all Class 2 felonies. 1 count of theft of means of transportation, a Class 3 felony, and 1 count of hindering prosecution, Class 5 felony. Now, your attorney's on the line, and Mr. Bradley, you're from the Public Defender's Office, so I'm appointing you to represent him, correct?
That's correct, Judge. Thank you.
Okay. And Mr. Bradley, did you wish to be heard?
Yes, I did, Judge. I had 3 things I wanted to address. One might be short. I represent Mr. Hayes in what appears to be charges from the exact same set of events. In CR 2024-008-003-001. In the documents the court sent to me, there's an indication that this particular case Mr. Hayes is here for now is a refile of an old case, and it's listed the 2024 case I just gave you. So I just want to make sure my understanding is correct that 2024 case will be dismissed and this new case will now take over as far as how we go forward. If that's the case, then the first of the 3 things I want to address, I don't need to address.
Okay, and counsel for the state, do you have any knowledge about that?
Thank you, Your Honor. I think that Mr. Bradley is most likely correct, but obviously, as the court is aware, this court doesn't have the jurisdiction to be able to dismiss that other case, but I would anticipate that the assigned DCA for that, the CR 2024 case, will be making a motion to dismiss that downtown in the appropriate venue.
And I can tell you the notes that I have on this case from the pretrial services is this is a refile of the older case. And previously there was it looks like a $2 million cash-only bond. So what I can write in this order is that this would not be in addition, but it would be a $2 million bond, which is what the grand jury judge set. But it wouldn't be in addition to the bond previously set.
And Judge, I did want to also address bond briefly.
Go ahead.
If the old case is going to get dismissed, then I'm not going to make any double punishment arguments or anything like that. But for the bond, I just asked the court to consider this. Mr. Hayes is indigent. He has a public defender, and he's had one since November, December. And Arizona Rule of Criminal Procedure 73B2B requires the bond to be, quote, the least onerous type of condition in the lowest amount necessary, end quote. Malone versus Superior Court 181 Errors 223 says, quote, bail set at a figure higher than an amount reasonably calculated to assure the presence of an accused to stand trial is excessive under the Eighth Amendment. And lastly, Judge, the Arizona Supreme Court also instructs, quote, in determining the amount of bail, that a court must consider the circumstances of each case. Well, Mr. Hayes does have family support and other things that in a release motion I would mention. I do just simply focus on his indigency status. A $2 million bond for Mr. Hayes is absolutely excessive because it doesn't comply with the Arizona rules or the Constitution, Arizona and the United States, that demand the least onerous necessary to secure his appearance. I'll leave it to Your Honor to consider lowering that bond. I would suggest $500,000. I am quite sure Mr. Hayes isn't going to go anywhere with that bond either. But $2 million is excessive for anybody. I'm a public defender. I've never had anybody who I've had a conversation with where I thought that was a bond that even made any sense to talk about. So when we're looking at the least onerous bond necessary to secure his appearance, $2 million is quite frankly, Judge, laughable for an indigent defendant. For someone that makes a lot of money, that's different. But Mr. Hayes, his employment history, he's worked places like restaurants, retail stores. He doesn't have any assets where he owns a house or anything like that. He has me here. He doesn't have a private attorney. So with that in mind, I would ask the court to consider making this a reasonable bond.
Okay, County Attorney, did you want to be heard?
Yes, Your Honor. The state would ask that the court affirm the grand jury warrant. First, as an initial matter, this is a grand jury warrant. The information, the factual basis for these charges, the current court is not aware of that. And so I think that it's certainly better and more reasonable for this court to follow the order of the prior judge at the grand jury, who was able to have some information regarding the underlying facts of these allegations. Obviously, these are all very serious felony cases involving a homicide and the actions that led up to that. So I think the court needs to consider that. I would point out to the court that in the factors that are enumerated, there is no specific reference to the court determining whether the bond amount is something that the defendant is able to afford to pay. Additionally, the factors that the court must consider are not limited to whether or not the defendant will appear for court. The court also has to think about the safety and protection of the community, the safety and protection of next of kin of the victim, as well as the safety and well-being of potential witnesses, things of that nature. So I think given the severe nature of these charges, the fact that the court has limited information about the factual basis, and additionally that Mr. Hayes is facing very significant potential consequences if he is convicted after trial, even potentially the possibility of the death sentence. I think that bond request, that bond amount is completely reasonable and is the least onerous given the facts and the charges that are he's here before the court on. Thank you.
Okay, thank you. Sir, your next hearing is going to be an arraignment, August 1st, 8:30, counsel.
Judge, that works for us.
Okay. And I am going to affirm the bond of $2 million. Obviously, the grand jury judge did have a lot of information or was given information in setting that. I'm not going to second guess that. But also, I am familiar with this case, and given the nature of the charges, I think that bond is appropriate. Anything else from either counsel?
No, Your Honor, thank you.
Judge, I had one last thing, and I'm glad you're familiar with the case, so you probably know this is a very high-profile media case. There have been stories throughout the course of the investigation, and since Mr. Hayes was arrested on the other case, many of them, if not all, have been prejudicial and jeopardized his right to a fair trial. We sit here today with Mr. Hayes being given his second initial appearance on, albeit some different charges from the old case. Some of the charges appear to be the exact same, but they stem out of the exact same facts, events, and dates from the old case. So what probably happens here is the media, like they did last time, may try to get a hold of this case and put Mr. Hayes' picture up there again, which will cause more prejudicial coverage for him, make it harder to get a fair jury. And it's completely gratuitous at this point because, like I said, there's other ways to go about this, and Mr. Hayes has already had an initial appearance for at least the same set of events. So I would just ask that the court seal this hearing as we move forward with this new cause number.
Seal the hearing?
Yes, Judge, correct. Seal it in the sense that it can't be released to the public, so we can embrace Mr. Hayes's due process rights, right to a fair trial, and prohibit any unnecessary new images of Mr. Hayes. And I do want to add, Judge, this case has a mistaken identity defense that was noticed in the prior case, and there are also identification issues in this case. Detectives often ask if people can identify Mr. Hayes, and I can tell you from reviewing the discovery in the old case, we start to see witnesses saying, yes, I've seen him on the news, but, maybe they say I've never seen him before, but that starts to blur some lines with identification. So with letting the court know we have noticed that defense and that there are, in addition to the defense, simply identification issues in the case, the less times new images of Mr. Hayes are put into the public, the better. And he has a right to due process, and there's simply no reason that this particular hearing needs to have new images put into the public. The media can certainly still report on it.
Okay, well, that is something that you will have to file a motion. We are not a court of record on this. The only thing I can do is if you're requesting, I can seal the Form 4. Let me tell you, I have not read one thing about this case in the newspaper. My only familiarity with this case is that I believe I've done a number of warrants in the past. So I'm familiar with some of the fact pattern on this case. I have not read or seen anything in the paper. So I would entertain a motion to seal the Form 4, if you would like me to do that, counsel.
But that starts to blur some lines with that. I mean, Judge, I would like you to do that, but here's the problem. If you want me to file a motion to address this, it's going to be too late. By the time I file it, the state gets 10 days to respond. I get, my 3 days to respond or whatever. This is already going to be out there. And you're right, Judge. Now that you mention it, yes, you are in some of the warrants in this case. That does sound familiar. But that's why I think it has to be ruled upon now, because the media is not going to wait around for a briefing schedule.
Well, I don't think I can order the media not to report on a case that's a public record, and they have the right to appear in court. So, but I will, unless there's some objection from the county attorney, I will seal the Form 4.
Your Honor,
County attorney?
the state does not object to you sealing the Form 4.
And Judge, can I just want to clarify so the court is clear on what I'm asking. I am not asking that the media can't cover this case. They absolutely can come to court, and I'm not asking that they can't. They can write an article about this new development, and I'm not asking that they can't. My focus is simply on the video and the images from this particular hearing, due to the past prejudicial coverage and the identity issues that I've explained to the court. Does that make sense? I just want to make sure. I don't want the court
No,
to think I'm asking. No.
Yeah, and I think that that's a motion that would need to be briefed. I don't believe that I can order that portion of the hearing to be sealed in any way. I don't know, I mean, there's no media in the courtroom right now, but I will seal the Form 4.
And Judge, I would just make one last request. I believe you absolutely have the authority to seal this hearing, but if you don't feel like you can seal it permanently, I would ask for a temporary sealing so we can at least brief the issue. And then if yourself or another judge decides it shouldn't be sealed, then it could simply be unsealed. But if you don't seal it now, yeah.
Yeah, given the fact that you already have this case in another, I'm assuming it's assigned to a judge that would be familiar with this case, I think you could file a motion Monday on an expedited basis to see if they would seal this. But I don't believe that I can do that without any type of research or case law to support this.
Well, Judge, I certainly can do that. Another issue is, will the case even be in the docket for me to have a judge to e-file? It isn't now, but I'll check Monday. But I can tell you that in past high-profile cases I've had, and I believe in this one as well, these things tend to get published right away. But if that's the court's ruling, I'll do my best.
Okay. Anything else from either counsel?
No, Your Honor, thank you.
No, Your Honor. Thank you for allowing me to appear virtually. Unfortunately, I just found out about this at like 7 a.m.
Yeah, no problem. Yeah, especially on weekends, we're always flexible on that. And just for the record, I did seal the Form 4.
Thank you.
Okay. Get your paperwork from the court staff. Zachariah Benjamin, come on in. And then Andrew Small to the chair outside the courtroom. Sir, state your name and date of birth.
Zachariah Benjamin, 42499.
All right, you have a failure to appear warrant for one kind of possession of narcotic drug, class 4 felony. You already have a court-appointed lawyer. Your next hearing is going to be a status conference July 31st at 8:30. I've set a $2,000 cash bond. Well, the judge did when you didn't fail to go to court. All right? Get your paperwork from the court staff. Andrew Small, come on in. And Antonio Valenzuela to the chair outside the courtroom. Sir, state your name and date of birth.
Andrew Small, 10/22/88.
You've got 3 matters. The first one is a Superior Court new case alleging one kind of possession of narcotic drug. Can you print this one out again? I don't know, I missed a click. All right. One count of possession of narcotic drug, class 4 felony. One count of possession of drug paraphernalia, class 6 felony. I've appointed a lawyer to represent you. Your next hearing will be a status conference, July 31st at 8:30, and I've set a $500 bond on this. Now, the next 2 matters are both probation violations. You're on probation for a class 5 and a class 4 felony. Probation is alleging you've now violated your probation by getting the new charge. That's called a term 1 violation. I've appointed a lawyer on both of these to represent you. Your next hearing will be an arraignment, possible disposition, August 1st at 8:30. And I've set a $900 bond on each of those.
Okay.
If you post these 3 bonds, you must contact your probation officer within 72 hours. All right, get your paperwork from the court staff. Antonio Valenzuela, come on in. Melissa Mundi to the chair outside the courtroom. Sir, Sir, state your name and
Antonio.
date of birth.
Antonio Valenzuela, January 30th, 1996.
All right, you're here on 2 probation violations. You're on probation for a Class 4 and a Class 6 felony. Probation is alleging you violated terms 3 and 5. I've appointed a lawyer on both of these to represent you. Your next hearing will be an arraignment, possible disposition, August 1st at 8:30. I've set a $900 bond on each. Now, if you post these 2 bonds, you must contact your probation officer within 72 hours. All right, get your paperwork from the court staff. Melissa, come on in. And then, Hero Montalvo to the chair outside the courtroom. State your name and date of birth.
Melissa Mundy, 3394.
You've got a probation violation warrant for your probation that you're on for a Class 6 felony. Probation is alleging you violated terms 1, 3, 4, 7, and 15. I've appointed a lawyer to represent you. Your next hearing will be an arraignment, possible disposition, August 1st at 8:30. I have a $750 bond. If you post that, you must contact your probation officer within 72 hours. Get your paperwork from the court staff. Pardon?
Not for cash.
No? Is cash bond? Is the cash bond?
Cash bond. Hero, come on in. And Maria Gastelum to the chair outside the courtroom. State your name and date of birth.
Laheterio Montalvo, 2000, September 4th, 2001.
You have a failure to appear warrant for 1 count of theft, Class 6 felony. You already have a court-appointed lawyer. This is on your probation. Probation is alleging you violated terms 6, 15, and 17. Can you print this out again? Your next hearing is going to be a non-witness violation hearing, possible disposition, August 1st at 8:30. And the judge sets your bond at $500. Now, if you post that, you must contact your probation officer within 72 hours. Okay, they're going to bring you your paperwork, okay? Yeah.
When you said I violated 3 times? Or is it?
6, 15, and 17.
Can you explain that to me, please?
Yeah, let me tell you what they are. Number 6, you absconded, did not report March 17th, April 21st. Last time you reported was February 17th. Number 15, you didn't pay probation service fees or probation assessments or a time payment fee. 17, you did not complete a total of 15 hours of community service.
Okay.
All right. Maria, come on in. Arthur Cessina. State your name and date of birth.
Maria Denise Castello, December 2nd, 1991.
You have a Superior Court arrest warrant alleging 1 count of possession of dangerous drugs, Class 4 felony, and 1 count of possession of drug paraphernalia, Class 6 felony. These allegedly occurred November 1st of 2024. I've appointed a lawyer to represent you. Your next hearing will be a status conference, July 31st at 8:30. I set a $500 bond. You can go through a bonding company. If you post that, you must contact your probation officer within 72 hours.
Okay, so it's $500? Okay.
Get your paperwork. Arthur, come on in. Landon Pace to the chair outside the courtroom. Sir, state your name and date of birth.
Arthur Cesenia, 7/21/1990.
All right, you have a Yavapai County Superior Court warrant for one kind of criminal littering or polluting. That can be a felony or a misdemeanor. I can't appoint you an attorney here. You're going to have to do that in Yavapai Council if you're eligible. Your next hearing is going to be an arraignment, July 29th at 8:30, and I've set a cash bond of $500.
Understood.
All right, get your paperwork from the court staff. Landon Pace, come on in. Richie Boy Hernandez to the chair outside the courtroom. Sir, state your name and date of birth.
Landon Rail Pace, March 28, 1995.
You have a municipal court new case for one kind of criminal damage, class 1 misdemeanor. You'll have a lawyer appointed for you at your next hearing for limited representation regarding the bond. Your next hearing is going to be an arraignment, July 30th at 1 o'clock. I set a $500 bond. You cannot return to the alleged scene of the crime. Understood? All right, get your paperwork from the court staff. Richie Boy Hernandez, come on in. Franklin Maynor to the chair outside the courtroom. Sir, state your name and date of birth.
Richie Boy Hernandez, 10/18/77.
You've got a probation violation warrant for your probation that you're on for a class 1 misdemeanor. Probation is alleging you violated terms 6, 12, and 15. I've appointed a lawyer to represent you. Your next hearing will be an arraignment, possible disposition, August 1st at 8:30. And the judge who assigned the bond set your bond at $300. If you post that, you must contact your probation officer within 72 hours.
Okay.
Get your paperwork from the court staff. Orlando? No, Franklin Maynor? And then Orlando Remus to the chair outside the courtroom. Sir, state your name and date of birth.
Okay, Menor, 11/7/63.
You have a Superior Court new case alleging 2 counts of possession of drug paraphernalia, class 6 felony, and one kind of shoplifting, class 1 misdemeanor. I've appointed a lawyer to represent you. Your next hearing will be a status conference, July 31st at 8:30. I set a $250 bond. Looks like you also have a warrant out of Phoenix. Have you seen the Phoenix judge yet? Okay. You'll have to see another judge as well. All right, get your paperwork. Orlando, come on in. Carlos Basico to the chair outside the courtroom. Sir, state your name and date of birth.
Orlando Remus, June 2nd, 1996.
You have a Superior Court new case alleging one kind of criminal trespass in the first degree of a residential structure, class 6 felony. I've appointed a lawyer to represent you. Your next hearing will be a status conference, August 11th at 8:30. I'm going to release you to pretrial services on an ankle monitor. You cannot return to the alleged scene of the crime. Understood?
Okay. I have a question.
At
the time of the event, At the time of the event, I was actually taking an Uber to the airport to leave. Before anything happened, I had even the Uber, it was there. I'm just wondering, the ankle monitor, is it going to prevent me from leaving the state?
Yep. I can't leave the state.
Okay. I don't have any family or nowhere to go out here, so.
I mean, you're going to be on an ankle monitor and you can't leave the state. Looks like you also have another misdemeanor pending.
Yeah, that was on August 4th was my next hearing.
Yeah, you got to stay around for court.
Yeah.
All right, get your paperwork. Carlos, come on in. So, to the chair outside the courtroom. Sir, state your name and date of birth.
Carlos Basoco, March 13, 1990.
You have a Superior Court new case alleging one kind of possession of narcotic drug, class 4 felony, one kind of possession of drug paraphernalia, class 6 felony, one kind of obstruction, refusing to give a true name, class 2 misdemeanor. I've appointed a lawyer to represent you. Your next hearing will be a status conference, August 11th At 8:30, I'm going to release you pretrial services with drug testing and monitoring. Do not miss court.
Okay.
Get your paperwork from the court staff. So, come on in. Sir, state your name and date of birth.
My name is August 1st, 1956.
You have a justice court new case alleging one count of an assault. That's a misdemeanor. I've appointed a lawyer to represent you. Your next hearing will be an arraignment, August 12th at 9 o'clock. I am going to release you on your promise to go to court, but you cannot return to the alleged scene of the crime. No contact with the victim. Got to live someplace else. Now, if you need to go there to get your personal belongings, at the bottom of your paperwork, it's going to allow you to call the police department in the area of town where this happened. They'll meet you there. It's called a civil standby. And then they'll allow you to go in and get your personal belongings. Okay? All right, get your paperwork.
Thank you, Your Honor.
Mm-hmm. And then Oscar Viller, why do we have a house call?
One second, Your Honor.
Combative, uncooperative.
For Mr. Billy, he's disruptive and unable to function in the
Oscar Viller, date of birth 1/17 of 1990. He's got a Superior Court failure to appear warrant for one count of possession of a weapon by a prohibited person, one count of possession of dangerous drugs, both class 4 felonies, one count of resisting arrest, one count of possession of drug paraphernalia. Those are both class 6 felonies. He already has a court-appointed lawyer. His next hearing will be a status conference, August 5th at 8:30. When he failed to go to court, the judge set his bond at $5,000. And then Tom Stockton, why is he a house call?
Refusing to follow orders, Your Honor, and unable to function.
Tom Lee Stockton, date of birth 8/14 of 93. He's got a Superior Court new case alleging one count of possession of narcotic drug, class 4 felony, one count of possession of drug paraphernalia, class 6 felony. I've appointed a lawyer to represent him. Next hearing will be a status conference, August 11th at 8:30. I'm going to release him to pretrial services with alcohol and drug testing and monitoring. All right, and we are off.